Thank you for selecting the Commission on Sentencing's Amendment 5 to the 7th edition Sentencing Guidelines module, which covers specific changes or modifications to Amendment 5. This module was created in April 2020 and is intended as a brief overview. More detailed information can be located on the Commission's website under the Sentencing Guidelines section or by contacting a member of the Education and Outreach Unit. This module will overview the following topics. First, we will review new sentencing enhancements, which include offenses of homicide and aggravated assault by vehicle when the individual was not properly licensed, and a sentencing enhancement for domestic violence offenses to include circumstances in which a minor was present and witnessed the offense by sight or sound. We will then move on to a brief description of new or modified offenses in which the Commission has assigned offense gravity scores. And finally, we will review any existing policy modifications and/or clarifications to the sentencing guidelines. Sentencing enhancements. First, we focus on sentencing enhancements for homicide and aggravated assault by vehicle when the individual is not properly licensed. In other words, when there was also a violation of Title 75, Section 1501 or 1543. Regarding the homicide and aggravated assault by vehicle enhancement, it is important to note the Commission has several enhancements related to these offenses already. For example, if a person is convicted of the stated offenses and they also were convicted of a DUI, or the violation occurred in an active work zone, or if they did not provide adequate space to first responders, or, more recently, if the individual was texting while driving, otherwise described in statute as prohibited text-based communications. Since the Commission has previously enhanced the base level offenses of homicide or aggravated assault by vehicle for various types of behaviors or violations, the Commission used the existing framework to accommodate this new enhancement for not being properly licensed. To best understand the enhancement, we'd ask that you reference the Commission's offense listing located at Section 303.15. Viewing the offense listing will assist you in identifying the various combinations of behaviors and violations and the corresponding OGS assignments. For example, let's use homicide by vehicle as the conviction offense. Homicide by vehicle is assigned an offense gravity score of 6. However, if the person was not properly licensed, the OGS assignment for the offense would be an 8. Additionally, if there were other factors present, such as a DUI conviction, the assigned OGS would then be a 10. The same method of assigning specific OGSs would apply to the offense of aggravated assault by vehicle if a person was not properly licensed and if additional factors were present. The final sentencing enhancement as part of Amendment 5 is the Commission's domestic violence enhancement. Information on the Commission's domestic violence enhancement can be found under Sections 303.9 and 303.10 of the Sentencing Guidelines. For background, the Commission was mandated to develop a sentencing enhancement for domestic violence offenses of aggravated and simple assault against a family or household member when the offenses were committed in the presence of a minor and the minor witnessed the crime by sight or sound. The Commission has considered creating an enhancement for domestic violence offenses previously and used this opportunity to expand upon its mandate. The Commission recognized domestic violence offenses go beyond aggravated and simple assault and, as such, expanded the types of offenses the enhancement would apply to. Let's discuss what offenses the enhancement applies to and the way in which the Commission achieves the enhancement. First, the enhancement would apply if the court determines the individual committed an offense under Title 18, Chapters 25, 27, 29, 30, 31, or 49, and the offense was against a family or household member as defined in Title 23, Section 6102. If the individual committed one of the stated offenses and it was against a family or household member, the offense gravity score assignment listed in Section 303.15 would be increased by 1 point. For example, if the offense was simple assault with an OGS of 3, it would be increased to an OGS of 4. Next, if the court further determines that an offender knew the crime was witnessed, either through sight or sound, by a minor who also was a family or household member, the Commission recommends the court consider ordering the offender to pay the costs or fees associated with the treatment of the minor for the exposure to domestic violence. OGS Assignments for new or modified offenses. The General Assembly often creates new offenses or modifies existing offenses, and the Commission reviews these and assigns offense gravity scores. Amendment 5 incorporated several relatively new or modified offenses since the 17-18 session of the General Assembly. Most notably was the creation of a Felony 3 offense for DUI. As part of Amendment 5, the Commission reviewed existing offense gravity score assignments for DUI offenses and decided to simplify the process. As we are aware, there are myriad combinations of DUI offenses that consider the BAC of the individual, the number of prior DUI convictions, whether a minor was in the vehicle, and many more. As a result, the Commission has an expansive list of varying OGS assignments for DUI. With the creation of a Felony 3, the Commission decided to link the OGS assignment to the grade of the DUI offense to simplify this process. For example, a Felony 3 DUI committed on or after January 1, 2020 would have an offense gravity score of 6. A misdemeanor 1 would be an OGS of 5, and a misdemeanor 2 an OGS of 3. As noted, there are plenty of other offenses which were assigned offense gravity scores. To view the remaining offenses, please reference the Commission's offense listing located in Section 303.15. Policy modifications and clarifications. The final portion of this module overviews several modifications or clarifications to existing policies within the sentencing guidelines. Specifically, we will discuss changes to offense gravity scores for convictions of delivery by practitioner, A14, and possession with intent to deliver, A30, when the substance contains fentanyl, its derivatives, and analogs. And last, we will highlight modifications to the offense gravity score of 15 for murder 1 and 2, and a change to the Commission's Youth School Zone enhancement. Hang in there, you're almost at the end. So, let's look at fentanyl and its OGS assignments. Before we highlight the changes included in Amendment 5, it is helpful to provide a brief history to assist in understanding what has changed. As you can see, in June 2018, the Commission subcategorized, for the first time, offenses of A14 and A30 of the Drug Act when the substance included fentanyl, its derivatives, and analogs. The Commission subcategorized by several weight categories which reflect the same weight breakdown for heroin. Further, the Commission used heroin offense gravity scores as the starting point for assigning OGSs to fentanyl and ultimately decided to increase each respective weight category by 3 OGSs. For example, if an individual was convicted of A30 for less than 1 gram of fentanyl, the OGS assigned was a 9, 3 higher than a heroin assignment of 6. This distinct increase in the assigned OGS reflects the serious and deadly nature of fentanyl. Additionally, the Commission discussed the difference between an individual who knowingly possessed and dealt fentanyl compared to a person who unknowingly possessed fentanyl, for example, thought they were dealing heroin. The Commission attempted to draft language for guidelines to draw a distinction between these two scenarios, but was unable to coalesce around appropriate and sufficient language. This brings us to the changes included in Amendment 5. Considering the above policy discussion and decisions, the Commission revisited the OGS assignments for A14 and A30, specifically when the substance included fentanyl of less than 1 gram. To mitigate the potential impact of an OGS assignment of 9, the Commission reduced the OGS for this weight category to an OGS of 8. While this decision may seem insignificant to some, we offer a broader view of the change. To assist in the explanation, please reference the Commission's basic sentencing matrix to best visualize the impact. Starting with OGS of 9 and prior record score of 0, the standard range is 12 to 24 months. If the court was inclined to sentence solely within the standard range, Even at the lower limit, the resulting sentence of 12 to 24 months would be a presumptive state prison sentence. With the reduction to an OGS of 8 for offenses of less than 1 gram and a prior record score of 0, the standard range would be 9 to 16 months. Again, if the court felt compelled to sentence within the standard range, the options to the court would include a county jail sentence or state prison sentence. Additionally, it is important to note the availability of probation with restrictive conditions, former RIP, D, and A, as a standard range treatment option for an OGS 8 prior record score 0. This was a key consideration of the commissions when discussing a change to the OGS assignment, specifically that a level 3-4 treatment option is available without the court mitigating from the standard range. If the court wished to mitigate from the standard range, the mitigated range would reduce the lower limit to RS, restorative sanctions, which include sentencing options of a fine, community service, and probation. Again, while the reduction by 1 OGS may seem small, the impact on the standard and mitigated range of the sentence recommendation is rather large. Please keep in mind the Commission's policy when a mixture or compound contains more than one controlled substance. If this is the case, the mixture or compound shall be deemed to be composed entirely of the controlled substance which has the highest offense gravity score. Next, we move on to changes to OGS 15 and the Youth School Enhancement. Regarding OGS 15, the Commission decided to include convictions of murder 1 and 2. Previously, the Commission reserved OGS 15 for convictions of murder 1 and 2 when the offender was less than 18 years of age. The Commission chose to include adult convictions in the OGS 15 assignment to assist the Commission in fully collecting sentencing information for these offenses. Additionally, the Commission is now requiring courts submit sentencing information for these convictions. Historically, the submission of such information was voluntary. And finally, we wrap up with changes related to the Commission's Youth School Enhancement. Before discussing the changes, let's review the enhancement prior to Amendment 5. The Youth School Enhancement is divided into 3 categories and applies to individuals convicted of a violation of A14 or A30 of the Drug Act. First, if an individual delivered to a youth, 6 months were added to the lower limit and 12 months to the upper limit of the standard range. This was the lowest of the 3 categories. If the individual delivered to a person in a school zone, 12 months were added to the lower limit and 24 months to the upper limit. This was the middle tier of the 3 categories. Last, if an individual delivered to a youth in a school zone, 18 months were added to the lower limit and 36 months to the upper limit. This represented the most serious or the highest of the 3 tiers. The Commission has discussed right-sizing the enhancement to reflect the perspective that delivering to a youth is more serious than delivering in a school zone. To make this distinction, as part of Amendment 5, the Commission flipped the months added to the standard range for youth in school, ultimately resulting in school being the lowest of the tiers, youth being in the middle, and of course, if the individual delivered in a school zone to a youth, it would remain the highest of the tiers. While these are the most prominent modifications and clarifications to the sentencing guidelines, we'd ask that you reference the published text of Amendment 5 to see all relevant changes. In summary, we have covered new sentencing enhancements, OGS assignments for new or modified offenses, and several modifications to existing sentencing guideline policies specific to Amendment 5. Remember, Amendment 5 became effective January 1st, 2020, and applies to offenses committed on or after this date. As with all of the Commission's trainings and seminars, we value your feedback. Please feel free to submit comments or questions related to this module via email to Ryan S. Myers, Manager of Education and Outreach. Contact information for Ryan and members of the Education and Outreach Unit can be found as part of this module or by visiting the Commission's website at pasentencing.us. Thank you for taking the time to view this module. Have a great day.